Hello, my name is Bernie Wolfsdorf. I'm the managing partner of WR Immigration. Today, we will make a comprehensive presentation on the new EB-5 law, which President Biden signed on March 15, 2022. Just very recently, we have a new EB-5 law. Vivian?
我们是美国 WR 移民律师事务所，今天的主讲人呢是我们的合伙人 Bernard Wolfsdorf 律师，我是他的合伙人 Vivian， 我今天会帮大家翻译他主讲的内容。我们今天主要的主题呢，就是在最近3月15号通过的 EB-5的新法，使区域中心项目顺利的延期。
Briefly, to introduce myself, my name is Bernie Wolfsdorf. I'm the managing partner of WR Immigration. I am here today with my partner, Vivian Zhu. Vivian is an EB-5 magazine top 25 lawyer. My understanding is she is the only Chinese-speaking EB-5 magazine top 25 lawyer, and in my opinion, she's actually top 5. Continuing, need to confirm that this presentation does not constitute legal advice. We will give you some general information concerning EB-5. If you need legal advice, please contact an immigration attorney. Vivian?
给大家一些 disclaimer， 今天的演讲呢不作为我们正式的法律意见，只是一个给大家一个对这个新法的一个介绍。如果大家对自己的申请有具体的问题呢，还是请咨询你们自己的移民律师。
As I mentioned, President Biden signed a new EB-5 law on March 15, 2022. This law actually replaces the previous EB-5 program, and there is a 60-day lead time before the new law starts. So we do not expect to see any adjudication before May 14, 2022 at the earliest. Vivian?
3月15号，拜登总统签字以后呢，这个 EB-5的新法它就已经正式生效了。但是呢，新法里规定说，这个新的项目它最终正式开始的时间是在新法生效后的60天之后，也就是2022年的5月14号。那么在这之前呢，移民局表示他们不会正式审核任何的 EB-5申请。
The purpose of this 60-day delay is to allow the government to prepare new forms, new regulations, new guidelines. It will also give the regional centers an opportunity to update their business plans and offering documents to make sure that they are in compliance with the new EB-5 law. And we will today give you the basic outlines of this new EB-5 Regional Center program. Vivian?
10天的生效日期的作用呢，主要就是用于移民局它作为一个国家的行政单位，在立法机关颁布一个新法之后呢，它需要有一段的时间来制定具体的实施措施。比如说，他们需要发布新的526申请表格，以及526递交申请的那个指示。另外呢，它同时也是给 EB-5项目方去更新他们的商业计划书和审核的材料，所以这个60天是非常必要的。我们今天的讲座呢，主要就是为大家初步的讲解这个 EB-5新法的一些重点。
Thank you, Vivian. And on with the new requirements under the new EB-5 law. First, the minimum investment amount for rural high unemployment, which is TEA, or infrastructure project will be $800,000. So to clarify, the minimum investment amount has increased from $500,000 to $800,000 if you are in a rural high unemployment or infrastructure project. And if you are not in one of those 3 areas, then the minimum investment amount has increased from $1 million to 1,050,000. So the difference is $250,000 between the regular EB-5 Regional Center and the TEA Rural and Infrastructure, which is now at 800,000. Vivian?
最重要的地方就是它把最低的投资额度从50万美金涨到了80万美金，而可以适用这个最低额度的呢，只是3类的项目，一个是在农村地区的，一个就是高失业率区，也就是我们平常所说的 TEA 地区的项目，第3个呢就是基础设施建设的项目。如果不是符合这3个类别的投资项目呢，新的投资金额就是105万美金。
And more so, the minimum investment amount will automatically increase every 5 years based on inflation. We have had quite high inflation in the US, I believe over 7%. So in 5 years, you will see the amount increase yet again. So waiting for the investment amount to go down doesn't make sense. Now, one other thing that is important is previously the TEA determination was made by states and local government. Today, only the DHS, only USCIS can make the determination to issue a TEA letter. And these TEA letters and these determinations will now be valid for a period of 2 years from the date the project files. And of course, these TEA letters will be renewable. Over to you, Vivian.
那就不是根据法案就是固定的投资金额了新法规定这个投资金额每5年可以根据美国的通货膨胀率进行自动的调整。另外呢，就是以前的 TEA 地区都是由州政府或者是当地政府来认定的，现在新法规定呢，只有移民局可以认定这个 TEA 地区的资格而且就是但是这个 TEA 地区现在变成了2年有效期，而不是以前的1年有效期了。当然，就是如果这个地区持续符合 TEA 资格的话，它是可以就是跟移民局申请自动就是申请它的认证的一个延期。Back to you, Bernie.
Thank you, Vivian. Now, the big issues. Let's deal with a few of the smaller issues. The good news. The EB-5 program has now been reauthorized to September 30th, 2027. So we do not have to worry about reauthorization for the next 5 years. And even better, we now have grandfathering of petitions which have already been filed. So during this recent 8-month plus lapse, everybody was terrified that maybe the petitions which had already been filed would not get processed. And that can never happen because of the fact that we now have grandfathering. And if there is a future lapse, everybody who filed before September 30, 2026 will be protected. So if you're going to do EB-5, it makes sense to do it now. But it certainly makes sense to do it before September 2026 because you don't even have to worry about whether or not the program will be renewed or extended beyond the existing 5 years. Vivian?
EB-5区域中心项目延期了5年，所以大家可以看到我们现在有一个5年的 EB-5区域中心项目了，甚至呢新法还给出了一个祖父条款。那这个条款的主要作用呢，就是保证以后这个项目再需要延期的时候呢，已经递交申请的申请人不需要担心移民局会搁置他们的申请。比如说像这次项目到期以后呢，移民局是停止了所有 EB-5申请的审核，但是有了这个祖父条款以后呢，以后就算这个项目要等待国会延期，已经递交的申请呢，还是可以得到正常的批复和审核。
Now, the big question, will the Department of State start processing I-5 and R-5 immigrant visas in the month of May. I-5 and R-5 are the regional center. The one is for rural, the other is for TEA or regular, non-rural. So the question is, the direct cases are being processed. Remember, only the regional center lapsed, so the direct EB-5 cases are being processed. The question is, when will the regional center cases be processed again at the National Visa Center? We are hoping this will start in May. We are hoping that we will see interviews scheduled in Guangzhou and elsewhere in the month of May, but we do not know. And the reason is that it takes time to get ready, get all the documents ready, but we are very hopeful that we will start seeing interviews being scheduled again in Guangzhou under the Regional Center program after May the 14th, so it'd be the second part of May, which is 60 days after the president signed the new law. So we are expecting to see Department of State process cases again. We cannot make promises, but we are hopeful. Vivian?
重要的问题就是大家最关心的问题，就是在5月份，那个国家签证中心和领馆是不是就可以继续发放 EB-5区域中心项目投资人的绿卡和宜宾签证了？但这个问题的答案呢，目前还不明确。我们看到就是在区域中心项目失效这段时间，直投的申请是正常批复并且发放绿卡的。但是呢，这次就是根据新法制定以后呢，我们希望可以，他们就是领馆可以从5月份开始就重新回到为 EB-5申请人安排面试的这个正常程序当中。但是没有人知道这个是不是一定能发生，因为就像我们之前说过了，之前新法颁定之后呢，政府它需要一定的时间去准备，或者说去解读这个新的法律，所以可能还需要一段时间。我们希望他们能从5月份，就是我们能看到 EB-5申请人可以在广州开始面试。
Thank you. Now we're going to talk about the new set-asides or reserved visas under the new law. Again, starting immediately, 20% of the 10,000 visas will be allocated to rural, 10,000 will be allocated for high unemployment areas, much like the TEA, and 2% or 200 visas will be allocated for infrastructure projects. So we have a total of 3,000 visas, approximately 3,200 visas, out of the annual quota of 10,000 being allocated and set aside for these particular categories. And the big question, which everybody has, is how will this work? Will this mean that the Chinese and others in waiting lines are going to get less visas? If that is the case, we're not very happy. However, it may take 2 to 3 years before these new petitions are actually processed. So if it takes 2 years for these petitions to be processed, it is very possible that these set-asides will not directly impact those people in the waiting line. The truth is, we don't know yet. We will see very soon how the government plans to do it. But at the moment, in the visa bulletin, it gives you 2 categories, basically direct and regional center. But in the new visa bulletin, starting probably in May, you will see 5 different categories. So under China, there will be 5 different waiting lines. There will be the old direct, there will be the old regional center, And then there will be these three new categories: rural, high unemployment, and infrastructure. What the cutoff date will be for these, whether these visas will be immediately available, we don't know yet, but it's very likely that we will see a new split visa bulletin in the month of May, which will regulate these new categories of reserved visas. Over to you, Vivian.
部分项目的投资人预留了签证的名额，大家也是非常关心这个预留签证是否会影响到已经递交 EB-5申请的投资人。我们可以看到，在这个3200多个预留的签证当中呢，就是它的新的类别是全新的，跟以前是不一样的，所以项目它需要根据这个新法的规定去得到移民局的重新认证，它才能享受到这个预留签证，就是这个新项目的投资人才能享受到这些预留签证的名额。但是呢，如果你递交一个新的526申请，很可能移民局审核时间又是2到3年的时间。所以我们认为这个预留的名额呢，在近期，就是在最近的2到3年当中，不会对已经在排期等待中的投资人有多大的影响。我们现在看到中国的 EB-5就是有2个排期，一个是直投的，一个是区域中心的。那等这3个就是新法当中预留名额被移民局履行以后呢，我们可能会在5月份的排期表中看到它为这3类的申请新的排期通道，也就是说以后的排期表里面它会有增加了3个新的类别，一个就是农村地区项目农村地区区域中心项目投资人，一个是高失业率区 TEA 项目的投资人，另外一个就是基础设施建设项目的投资人。所以这些它会通过开辟新的排期通道来规定新的签证名额，但是在近2到3年当中呢，应该不会对已经递交申请的老投资人有任何实质性的影响。
Two other important requirements for people who want to understand the program completely is in the regional center or indirect job creation. It used to be that you could create 100% of the jobs indirectly. Under the new law, you have to create at least 20% direct jobs and only 80% indirect jobs. So if you are using economic job multiplier programs, you are limited to only using those for up to 80% of your job creation. The other 20% have to be actual jobs, such as operational jobs, management jobs, but physical jobs as opposed to economic input indirect jobs. Vivian?
就是将区域中心以经济计算方式来计算创业的这种办法呢，受到了一定的限制。在过去呢，区域中心项目它可以100%的工作都是由间接工作机会，就是由这种经济学计算方式来创造的工作。但是在新法下呢，它限制这个间接工作只能达到最高到80%，那么就有20%的工作呢，必须是由直接的，就是大家能看得到的这种工作来计算。比如说你投资一个酒店，那现在只有80%的工作可以用到建筑工人这样子的经济学计算方式来算作工作的机会，那20%的工作只能是通过这个酒店，就是项目建成酒店运营以后的运营工作来作为就业创造的一个计算方式。
The other very important part of EB-5 is redeployment. Because many Chinese applicants have been stuck in the waiting line, the question is, do they have to redeploy? And the answer is, sadly, they do have to redeploy within a reasonable time of the loan maturing, assuming it's a loan model situation. So if the loan matures after 5 years and the money is returned, then it does have to be redeployed, put at risk again. The good news with this law is that it no longer, or it's very clear that it doesn't have to be redeployed within the geographical location of that regional center. when it is redeployed, it can be redeployed anywhere in the US. So that gives the investor a little bit more flexibility as to selection of projects, but it's a little bit unfair that those people stuck in the waiting line also have to have their money redeployed up until they arrive in the US and file the 829. When they file the 829, after they filed, the money does not have to be redeployed. That is the removal of conditions. So for many Chinese applicants, the money may be committed longer than normal, and we encourage investors to understand what the redeployment provisions are, because many people are surprised to discover that they have to redeploy anywhere in the US under the new rule in order to get the full green card further down the road. And it is not only regulated by the subscription agreement, it is also regulated by the statute, the new law, which allows reasonable redeployment within a reasonable time anywhere in the US. Over to you, Vivian.
中国的投资人呢，他们关心的另外一个问题就是再投资的问题，因为中国的排期比较长嘛，所以根据法律规定呢，在投资人的临时绿卡2年有效期到期之前，他们的投资款都必须处于一个风险投资的状态。所以如果你第一次投资的项目那个时候已经建完了，并且就业创造都完成了，然后开发商已经把钱还给美国公司了，但是投资人还没有拿到绿卡，就是他的临时绿卡2年有效期还没过的话，那么这个投资人就是按照法律的要求，他必须要把投资款再次投入到第二个项目当中去，以保持这个投资款的风险投资状态。那么在过去呢，移民局的规定就是比较限制的，就是你在投资的话，这个项目必须是跟前面那个项目有一定的相似度，比如说他们的位置、他们的类别等等。但是这个新法呢，它就给了我们一定的就是解开了一定的这种限制。它新法规定就是再投资项目可以在美国的任何地方。所以只要是这个投资款是保持风险投资状态的，你选择的再投资项目可以是在美国任何城市、任何位置，这个不再受地理位置的限制了。所以大家也必须就是作为中国投资人排期比较长的这种情况呢，希望大家也就是去多了解这个再投资的这个要求。所以你不一定只是符合一个投资项目就可以了，因为要保持风险投资状态的话，你可能投资款要完成一个项目之后再投到下一个项目里面。Back to you, Bernie.
Thank you. Now I want to deal with the complicated issue of adjustment of status. And it's very important to understand that when you apply for EB-5 green card, there are two places where you can pick up the green card. For most Chinese applicants and most applicants worldwide, the majority of cases are processed at the U.S. consulate in Guangzhou or U.S. embassy in whichever country you're applying from. Now, because of COVID and other reasons, there are estimated to be hundreds and hundreds of thousands of petitions stuck at the National Visa Center. Staffing has been reduced and cases are not moving at the NVC or the National Visa Center. So many clients are very frustrated. And it appears that this new statute opens a door to apply for adjustment of status in the US. Now, this has always been possible, but the big difference is that if your priority date, if your place in the waiting line is current, if there's no waiting line, then technically you can file both the I-526 petition and the 485 together. Now, unfortunately, we do not expect the Chinese visa bulletin for the month of May to be current. So it is not clear to me that Chinese applicants will be able to do this under the regular categories. But as I mentioned, there may be 5 separate categories in the new visa bulletin. And it is possible that some of these categories may be current. For example, the high unemployment area TEA category, for example, the rural category, and for example, the infrastructure category. So for 3,200 of these visas, it may be possible for new Chinese investors to file both a 526 and 485 together, provided USCIS permits this in the month of May. Now, we are very hopeful that the State Department will start moving the visa bulletin beyond December 2015, which is where it is stuck for Chinese applicants. My understanding is that there was an expiration of the 3-year program in September, scratch that, in late 2015, causing a huge backlog. Once we get past this 2015 Chinese backlog, my understanding is 2016 and even 17 will move faster. But in the meantime, we do have a situation where it may be possible in May or even June for Chinese applicants to file one-step application, that is I-526 and 485 together in May or June. We don't know. We do not know for sure. But if it is possible to file one step, I-1, I-526, 485 in May or June for persons from China, that will be a huge advantage to these new visa applicants, not so much for the people who've been waiting in line. And the reason why I say not so much for the people who are waiting in line is China is still subject to a 7% per country allocation. And China, with 1.5 plus billion people, gets the same annual allocation as a small country, which is not right, but that's the way it is. So, Vivian, over to you to explain this situation with the possibility that the May visa bulletin may or could be open, we don't know, for certain categories, which are the set-aside categories under the new law.
就是大家都知道，新的法案允许投资人同时递交485身份调整。那么哪些投资人可以符合这个条件呢？在过去呢，我们看到大部分就是有2种方式可以让 EB5 投资人拿到绿卡。第一种是，如果这个人已经在美国，他的526批准了，并且排期到了，他可以递交485。那么我们大部分的 EB5 投资人呢，是通过领馆，广州领馆来拿到 EB5 移民签证的。但是因为在过去呢，过去2年因为疫情的影响，广州领馆它也积累了大量的那个申请，并且几乎没有安排EB5 的面试。那这次根据新法呢，就是在有签证名额的国别投资人的那个情况下呢，你是可以递交526申请和485申请的。那么对于已经递交526申请的投资人来说呢，这个新法没有多大的作用，除非就是说你的排期已经到了，并且你是在美国的话，你可以尝试在美国递交485。但是因为现在 B 表还没有更新嘛，并且就是说它在 B 表，移民局在 B 表下面的标注是仍然就是说我们现在有一个新法，我们还需要对新法进行解读，所以也没有给出明确的指示能不能交485。但是对于还没有递交526申请的新投资人来说呢，有一种可能性就是我们刚刚提到的， 在5月份，如果他们开辟了新的3个签证排期表给农村地区项目、TEA 地区项目以及基础设施项目，如果开辟了新的排期表，并且这3个类别的项目排期它都是一个有名额的状态，那么投资在这些项目类别的投资人，他可以递交526申请和485申请。如果是已经在美国并且有合法身份的人，他可以同时递交526和485申请。但是我们现在还不知道他是不是一定会给这3类新的项目开辟新的排期，就是单独为这些预留名额的人开辟排期。而且我们也不知道，如果他开辟新的排期通道的时候，这3个通道对于中国人来说，它是不是一定是一个 current， 也就是有名额的状态。但是有这个可能性的话，那么对于中国投资人来说，这是一个非常好的机会，就是在美国递交526申请的同时，也可以递交485的身份调整。那么大家都知道，这个485申请呢，对于在美国的人来讲呢，是一个非常有利的一个东西，因为递交以后，你就可以拿到一张临时的工卡和旅行卡，你就可以在美国工作以及出入境美国。因为现在的那个 Combo Card 它的有效期也变成了2年，所以只需要2年一续了。就是对于在美国学习或者工作的人来说，是非常有利的一个东西。Back to you, Bernie.
Thank you, Vivian. And Vivian, as you correctly explained, if you can file the one-step application or file your adjustment under Chart B if USCIS allows it, then the good news is you should be eligible for the combo card, which is the work and travel card. I'm hopeful that they will get down to 6 to 8 months again. It used to be 3 or 4 months, but recently the processing has been very slow. But the advantage is that for people who are in the US in lawful status, they will be able to apply to one-step their application if the priority date is current and if the USCIS allows adjustment for that particular month. Only by reading the visa bulletin will you be able to find out if employment cases will use Chart A or Chart B. The government has been quite generous in keeping Chart B open, but unfortunately, we could not file regional center cases. We could only file direct EB-5 cases, which we do not encourage as much as the regional center cases, because the regional center program generally provides better protection for investors in this program. Now, the other thing that I wanted to mention is that the government has also provided for 245K protection for EB-5, which is very good. This will allow people who are out of status or have up to 180 days of unauthorized employment since their last entry. So the person could technically have been out of status for 9 months, but then re-entered on an H-1B. And if they are now out of status for less than 180 days, they are eligible to file for the EB-5 program. The third and final point that I want to make is the person has to have lawful status. At the time we file, up to 180 days of unlawful status can be excused. I am concerned that many people will try to come in on a tourist visa and then file the 526 and the 485. They do need to be cautious because there could be visa fraud. If a person comes on a tourist visa with a plan to file for a green card, that is regarded as visa fraud. There are circumstances where a person may be able to change their mind and file after more than 60 days is the USCIS rule on visa fraud. The State Department rule is 90 days. So my advice is to be as conservative as possible. If there is a change of intent, it certainly has to be after 90 days. And then as a question of fact, it has to be that the person did not come with an intention to stay, possibly only discovered about the program 2 or 3 months after entering the US. Also, those people on F1, student visas, OPT, H1B, L1, E2, or O1 visa, if they are in the United States and a visa number is available under one of the set-aside categories, they will be able, by available, I mean the visa bulletin is current, they will be able to file under this new program a combined 526 and 485. Again, we don't know that Chinese applicants will be able to, but it is very likely that some of these set-aside categories will be open for new Chinese investors, which is very unfair to those people who have been waiting in line for many years. But the law is the law, and I am expecting this door to open in the month of May and June for people in the US to file one-step 485 adjustment applications. I know that's a lot. Over to you, Vivian.
新法呢还为递交 EB-5 485申请的人提供了一个 INA 245K 的保护措施。那这个措施呢是指在美国，如果你有一定程度的违反签证法律规定的情况下，只要这个违反的行为不超过180天，你还是可以递交485申请的。那么如果没有这个保护措施的话，你在美国是必须一直保持一个合法的身份状态，然后才能递交485申请。有了这个法律了，比如说你在美国没有低于180天的情况下，你有过无合法身份状态，或者你前面一个签证已经到期了，但是你还就是一直没有离开，或者是你在学生身份的情况下在没有合法的工作授权的情况下就是进行了工作，这样子的情况，只要你的违法行为没有超过180天，那么你还是可以受到这个 245K 条款的保护，可以递交485申请。那么有很多人就想说，那我就拿 B1、B2 的那个旅游签证到美国来，然后呢，我再递交526和485申请。这个我们必须要提醒有这种计划的人，这个是一个很明显的一个签证欺诈的行为，就是需要大家警惕。因为你拿着 B1、B2 旅游签证进来的时候，你会跟海关说我是来短期访问或者我是来旅行的，但是呢，你入境之后就递交了485移民申请，递交了526移民申请，那么很有可能移民局以后就会认定为你在入境的时候跟海关说谎了，就是一个签证欺诈的行为。所以通常呢，我们会建议就是你要有一个足够的理由，你才能在 B1、B2 的基础上递交485申请。比如说你入境90天以后发生了一些重大的变更，比如说亲人生病或者你自己生病不能离开，然后你又突然发现了这个递交移民申请的这个机会，或者是学生签证的话，它也是不允许有移民倾向的。所以拿学生 F1 签证来读书的人呢，他进来之后也是必须要等待一定的时间以后才能递交这个485申请的。Back to you, Bernie.
Thank you, Vivian. Now, the good part about this law is that there are numerous integrity reform measures. These are designed to protect investors. They are much needed. And again, I am very happy that these have been implemented. There are new record keeping requirements, new audit requirements to visit, checking the fund administration, checking site visits to make sure the jobs are actually created. There are new audits every 5 years for the regional center. They also have to do annual recertifications. They are in compliance with security laws. So those people who are not following the law can get into trouble with the government authorities. And it is necessary now for agents and third-party promoters to actually register with USCIS. Generally speaking, all of these requirements are good measures, and we support them because they will help protect investors. Vivian?
加了诚信条款。总的来说，这些诚信条款都是非常有必要的，我们认为是好的变化。主要就是规定区域中心和项目方他们必须符合美国证券法的规定，向投资人披露所有相关的项目信息，包括所有参与项目的开发商，然后主要合伙人，以及就是帮助这个项目推销的各个中介或者第三方的推荐人。这些人呢，理论上来说都是应该要向移民局注册的，所以我们觉得这些诚信条款呢，也帮助这个整个 EB5项目的透明度有了极大的改善。另外呢，就是EB5项目方呢，他需要在每5年进行一个 audit， 就是一个审计的一个行为，然后每1年呢需要通过移民局和相关的美国证券法的一个认证和注册。所以这些条款都是对于整个 EB5项目的诚信有极大的推动，因为我们知道过去曾经多次发生过 EP5项目的欺诈或者是项目方不违规操作的一些行为，而造成这个项目一直有巨大的争议。所以我们看到这些诚信条款可以帮助这个整个 EB5项目它有一个透明度的一个增加。Back to you, Bernie.
Thank you. Yes, this program is over 30 years, and we are definitely in need of these integrity reform measures to protect investors. So this is a good thing again. One of the things that's being done is they are creating an EB-5 Integrity Fund. This will be based on annual fees paid by the regional center and, unfortunately, also by investors. So we are expecting to see an increase in the filing fee, the 526 filing fee, approximately $3,600. I think that's going to go up, and those funds will go into an integrity fund for defrauded investors. So I'm very happy with that. The second good thing is that good faith investors, people who invested in a regional center or a new commercial enterprise or JCE, and if that new commercial enterprise is debarred or the regional center is terminated because it hasn't been doing the correct thing, there are protections for investors so they can continue with their green card process, possibly with a new regional center. So again, these are all very good changes and protections for EB-5 investors that we strongly support.
诚信条款，它还同时创造了一个 EB5诚信基金。这个基金呢，将会有区域中心的年费以及申请人的526申请费来赞助。所以我们可能觉得这个526申请费它会再次的涨价。现在的费用呢是3675每一个申请。那么如果以后就是这个新法60天之后呢，可能随着新的526表格的颁布呢，这个申请费也是会增长的。另外呢，他还给出了诚信的善意投资人一些保护的措施，就如果区域中心不是因为投资人的错误，区域中心被关停或者项目被关停的这样的原因的话，某些善意的投资人可以得到相关的保护，但是这方面的具体实施的措施呢，我们还要等移民局进一步的规定。
Thank you again, Vivian. Vivian, my partner, is one of the smartest EB-5 lawyers that I know. Thank you for your assistance. I will point out one other fact. Very interestingly, in the month of March and the month of April, China is open under the direct EB-5 program. It is not 100% clear that they can file one-step 526, 485. Some people are going to take a chance and do that. We are not recommending it, but there may be an opportunity in the month of, well, March is almost over, April, for people to file under the direct program because those categories are current. Today's presentation is about the regional center program, which will not start until May 15. And also, as a word of caution, some people are concerned that the government will not be ready in 60 days to accept these cases because they can be quite slow. But by law, one should be able to file cases on May the 14th It is a Saturday, so they'll only get filed on the Monday. But we are seeing considerable demand for EB-5. The program is moving forward. We think this is a better program, but we also think that there have been 15,000 visas wasted last year, and the estimate is as many as 15,000 visas are wasted this year. I personally feel that these 30,000 visas need to be recaptured and allocated to the Chinese nationals who've been waiting in line for years and years and years. It is shameful that 30,000 visas or close to 30,000 visas are being wasted when we have 50,000 Chinese applicants waiting in line. My hope is that the government will improve this law through a technical amendment to avoid wasting the 30,000 visas that would clear the Chinese backlog, because what I'm not happy with is there's no age-out protection in this new law. There's only age-out protection if the 829 is denied through no fault of the investor. In that case, they can file a new 526 petition within 1 year of the 829 denial, but and child is protected even if the child is 24 or 25. That is only if the removal of condition is denied and the investor makes a new $800,000 investment is the child protected. So we do not have adequate protection of children in this new law. We have some protection of children for the time the petition is pending, but we do not have complete protection if the visa is in a backlogged category. You cannot get CISPA, Child Status Protection Act, in a backlogged category, but under the new law, if the 829 is denied, then the applicant can file under a new 526 within 1 year of that denial, and the child will not age out. But we do have a problem that there is no general age out protection other than for the time the petition was pending. I know that's a lot, but let's share that to some degree with our audience, Vivian.
今天的讲座呢，主要是关于 EB-5区域中心项目的，但是我们也想提一句，就是在3月份和4月份的那个排期表呢，中国直投它的那个排期表显示是有名额的，所以有些人他觉得想要尝试一下，他要在这2个月递交直投的526和485申请我们虽然不推荐直投项目，因为就是风险通常比区域中心要大一些，但是如果你想尝试一下，这也无可厚非。另外呢，就是区域中心的新申请呢，当然只能是在5月中旬以后才能开始递交，恰好这个60天的时间呢是在5月15号，是一个星期天，所以也只能等到星期一，就是5月16号才能继续递交新的526申请。有些人觉得那个移民局到那个时候可能还没有准备好，因为这个时间60天的时间来消化一个新的法案确实是比较短的，作为一个政府部门，他们有大量的规定必须要制定，但是就根据法律而言呢，他们是必须要就是接受新的526申请的。另外呢，我们认为新法没有做到的一点就是它没有很好的利用我们今年和去年所浪费掉的这个大概有3万个EB-5签证名额，我们觉得因为中国投资人已经等了那么多年了，他们还一直在浪费EB-5签证名额，这是一个非常不应该的。另外呢，就是新法没有为超龄的孩子提供足够的保护措施，它唯一提供的一个保护措施是在829申请被拒以后，你比如说你的项目失败了，或者区域中心被关停了，项目被关停了，你的他要求那个投资人在829被拒以后1年之内投入新的投资款，递交新的526申请，只有在这样的条件下呢，孩子的年龄才能根据第一次EB-5的申请得到保护。这个限制的条件非常的大，所以对于我们很多投资人来说并没有一个实质的帮助，它不是一个完整的一个 CISPA 的保护措施，所以这也是让我们比较失望的地方。Back to you, Bernie.
Thank you, Vivian. And for our audience today, I hope this information is helpful. We are still very new. It's only 2 weeks since the president signed the new law. We are waiting for regulations. We're waiting for more guidance. So much of this is based on our early interpretation. Some of the conclusions may change over time, but we thank you very much for joining us today. To reach us, it's best to contact via email. There's my email address, my partners, Joey Barnett and Vivian Zhu. Thank you so much. It has been a pleasure presenting to you today. For more information on WR immigration, please contact us at www.wolfsdorf.com. And thank you again, Vivian. If you could close, I would be most grateful. Thank you again.
因为我们现在这个新法它只是颁布的时间还比较短，就是2周之前才刚颁布，所以我们现在也在等政府那边给出更多的指示意见和具体的操作措施。所以今天的讲座呢，只是我们一个初步的对新法的解读，而这些解读呢，可能随着政府更多的措施出台以后会有所改变，所以我们也会跟我们的客户进行报备，如果有重大的变化的话，我们也会让大家知道。那么如果大家有问题，可以通过这个PPT 上的邮件联系我们。谢谢大家收听我们今天的讲座 ，Thank you。